committee will come to order. I recognize the gentleman from Iowa, Mr. Mizvinsky.
Thank you, Mr. Chairman. I have an article at the desk.
The clerk will read the article.
Immediately after Article 3, add the additional article, Article 4. In his conduct of the office of President of the United States, Richard M. Nixon, in violation of his constitutional oath, faithfully to execute the office of the President of the United States, and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty to take care that the laws be faithfully executed, did receive emoluments from the United States in excess of the compensation provided by law pursuant to Article 2, Section 1 of the Constitution, and did willfully attempt to evade the payment of a portion of federal income taxes due and owing by him for the years 1969, 1970, 1971, 1972, in that, 1, he, during the period for which he had been elected president, unlawfully received compensation in the form of government expenditures at and on his privately owned properties, located in or near San Clemente, California, and Key Biscayne, Florida. 2, he knowingly failed to report certain income and claimed deductions in the years 1969, 1970, 1971, and 1972 on his federal income tax returns, which were not authorized by law, including deductions for a gift of papers to the United States valued at approximately $576,000.
Mr. Chairman, I ask unanimous consent that all debate on this article, including the consideration of any amendments thereto, be limited.
The gentleman will defer until the clerk has read. Otherwise, he will ask unanimous consent that further reading be dispensed with. Clerk will proceed.
In all of this, Richard M. Nixon has acted in a manner contrary to his trust as president and subversive of constitutional government, to the great prejudice of the cause of law and justice, and the manifest injury of the people of the United States. Wherefore, Richard M. Nixon, by such conduct, warrants impeachment and trial and removal from office.
Gentleman from Iowa.
Thank you, Mr. Chairman. I ask unanimous consent that all debate on this article, including the consideration of any amendments thereto, be limited to a period not to exceed 2 hours, to be divided equally between proponents and opponents of the article. Debate on any amendment shall not exceed 20 minutes, divided equally between proponents and opponents of the amendment.
Mr. Chairman.
Clerk will read the amendment.
Amendment by Mr. Wiggins. On page 1, in subparagraph 2, add the words, and fraudulently, after the word knowingly.
The gentleman is recognized.
I shall only take a few moments with respect to this amendment, and perhaps there can be some agreement between myself and the author of the article so as to make extended debate on this question unnecessary. The reason that the language "and fraudulently" is added to the second subparagraph is because there is an ambiguity on the face of the article between the introductory language, willfully attempt to evade, which tracks the language of Title 26, Section 7201, and the language of subparagraph 2, which does not interject the element of fraud in its text. It is my belief that the gentleman from Iowa intends this to be a fraud case, and that there is no intentional omission on his part with respect to subparagraph 2 to remove elements of fraud as the proper thrust of the case. And if that is in fact his intention, then I see no reason for me to pursue my amendment since we are in agreement, and I'll be happy to yield to the gentleman from Iowa so that he can state his intention.
Thank you. I accept the amendment from the gentleman from California.
I appreciate that, and Mr. Chairman, that being the case and believing that the members of the committee will similarly accept the amendment, I think it now narrows the focus of the debate. We will be talking about whether the President has committed fraud in the preparation and execution of his tax return. And all debate on extraneous matters, although interesting perhaps to some, will not bear directly on the issue before us. This committee has been complimented, Mr. Chairman, over the days immediately prior to this on the high caliber of our debate, and I'm confident that we will confine our debate this evening to the issues before us, especially after the adoption of the amendment which I have made. I move the previous question on the amendment.
Question is on the amendment offered by the gentleman from California. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed?
Title and citation, if I might, before I vote. Thank the gentleman.
Chair will state that the question had already been before the committee. The question is on the amendment offered by the gentleman from California. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed? The ayes have it, and the amendment is agreed. Mr. Chairman. Mr. Hutchinson.
I'll claim the time on this side, and I'll yield 5 minutes to Mr. Wiggins.
Mr. Wiggins is recognized for 5 minutes.
I thank the chairman for yielding. Ladies and gentlemen, we reached an agreement a few moments ago that what this case was all about was the willful evasion of taxes. We know, although the gentleman from Iowa causes me to doubt that he knows, that this case has nothing to do with an innocent mistake. If the president, in fact, erred on his income tax, but did so innocently, or relied in good faith upon his counsel, then we are not talking about tax fraud in this case. It is a sweeping, inaccurate statement to say that any citizen who claimed an improper deduction in this amount would be criminally prosecuted. That is not so. Such a prosecution can only proceed if there is fraud. And I want to discuss the evidence, not a theory at all, but the evidence with respect to whether or not fraud exists in this case. This story began in the fall of 1968, ladies and gentlemen, after the election, when the President-elect Nixon met with President Johnson. President Johnson recommended to President Nixon that he might consider giving as a gift and taking a tax deduction certain pre-presidential papers. President Johnson recommended to President-elect Nixon the name of an appraiser, one that Mr. Johnson had used when he claimed his deduction. The appraiser's name was Newman, and he was from Chicago. President Nixon apparently felt that was worthy of pursuing and contacted his law partners up in New York, the firm of Nixon, Mudge, Rose. And an attorney proceeded thereafter to perfect a gift of certain pre-presidential papers for the taxable year 1968. Now, that was the only presidential involvement in the year 1968. President-elect Nixon talking to President Johnson and dealing through his attorneys concerning a gift. We move now into the year 1969, which is the critical year insofar as presidential actions are concerned. In February of that year, John Ehrlichman sent a memorandum to the president in which he discussed tax planning for the president and suggested that the president might well consider making a gift of his pre-presidential papers. There was no question at that time as to the propriety and lawfulness of making such a gift if it were properly perfected. The only presidential act, so far as our record disclosed, is the president writing on the bottom of that memorandum the word good and a few odd sentences with respect to a foundation. But the word good is the operative word, suggesting that the president was instructing Ehrlichman to go forward and perfect the gift of his pre-presidential papers. The president now is removed from the picture for a period of many months. Thereafter, John Ehrlichman and Ed Morgan of the White House, in cooperation with Mr. DeMarco, a tax attorney out in the Los Angeles area, performed certain acts for the purpose of claiming a gift. I make no claim, ladies and gentlemen, that they acted properly. That will be determined at a later time. But we're talking about the president's actions and his alleged fraud. The president played no role, ladies and gentlemen, in that at all. The next act of the president is in a social occasion at the White House when he meets Mr. Newman, and as Mr. Newman goes down the social greeting line, and we've all had some experience in that, there was a brief exchange about the appraisal of the pre-presidential papers. Thereafter, the next act occurs in December. The president signs a bill, a tax reform bill. And the final act upon which this whole case is premised is that in April the 10th, 1970, Mr. DeMarco and Mr. Kalmbach, his two attorneys, come to the Oval Office with a completed tax return. They spend approximately 35 minutes in the Oval Office, a portion of which was devoted to pleasantries, approximately 10 minutes of which was devoted to the tax return itself. It is stated by the witnesses that they went over it page by page, and now critically, ladies and gentlemen, critically, the evidence is that the president's attorneys then and there stated to him that these deductions were properly taken, and the president signed the return. A few moments thereafter, Mr. DeMarco took the return upstairs for Mrs. Nixon to sign, and that's it. That's all the evidence we're talking about. Now, on that, this web of fraud is spun. And I suggest to you, ladies and gentlemen, it is wholly, wholly unsupported in the evidence.
5 minutes of the gentleman has expired.
I'm asserting
We don't
what
have any
I
evidence of
what.
that. That's just a draft report. Even the committee doesn't assert the truth of that.
I don't think there's any question about that, Mr. Wiggins.
If the members would like to interpose objections, they should address the chair. I think the gentlelady is making reference to material that has been properly before the committee. Many of these documents have been received at the request of the chair with the concurrence of the members from the various committees of Congress, and this is matter that is properly referred to.
Chairman, I'm objecting on the ground it isn't before us. If this report has been made a part of our record and introduced into evidence here, then I wouldn't object, but I don't believe it has been. It's a Senate report, which there may have been mentioned here sometime. I don't recall it was ever placed in our record. It certainly was not testimony before us.
The gentlelady is recognized, and the gentleman's point of order is not sustained.
Let's look at the record before us and the law applicable thereto for just a moment. There are two parts to this proposed article. One deals with allegedly unlawful compensation said to be acquired by the president through government expenditures at his privately owned properties, which were not legitimate government expenditures according to the allegation. The other is income tax fraud. Now, as has already been pointed out, no fraud has been found, and in fact, there has been a contrary finding. You understand that these expenditures, which are allegedly improper, are charged to the president as income. So, because of that technicality, the author of the amendment has charged the president with violation of that constitutional provision on the theory that this is additional income, which says that the president shall not receive additional emoluments beyond his statutory compensation. Now, that is indeed a novel theory, and I call it reaching. It's a civil argument as to whether these things were proper expenditures or not, and whether they're income or not. Most of them were security matters approved ahead of time by the Secret Service. All of them were paid for by the government, and some of them were debatable and were finally decided by the Internal Revenue Service and the Joint Committee that they ought to be disallowed, and then they were classed as income. Pure civil arguments, such as happens between taxpayers and the government every day in the week. Now, technically, under the income tax laws, when you lose one of those arguments, you've got some additional income. But that makes you guilty of a constitutional violation of exceeding emoluments in excess of your salary because you lose an income tax argument with the Internal Revenue people is truly reaching, as I say. It's truly a novel approach. If there were anything wrong here, and it's been found to the contrary, it would have to come under Section 641 of the Code, which makes it a criminal offense to knowingly convert government property to your own use or to knowingly receive government property to your own use knowing it is government property to which you're not entitled. But of course that's a criminal offense. It requires a fraudulent intent. It can't be proved, so it wasn't alleged. So they go to this esoteric, theoretical violation of the Constitution of the United States. Now, let's go to the matter of income taxes. There again, purely a civil argument. Everybody realizes that this gift of the papers is all right if it's done on time. Now, normally you don't need a deed for a gift. You deliver the property with the intent to make a gift of it, and the other people accept it, which is usually inferred from the fact that they latch onto it and keep it and don't let you have it back, which is what's happened here. There's a gift. You don't need a deed, not normally. I don't know whether you needed one here, but the president said, probably unwisely, that he'd let these politicians on this committee decide the thing, so he's stuck with it. I'll bet you
Time of the gentleman has expired.
any lawyer could have won the case for him. There's no fraud.
30 seconds to the gentleman from California, Mr. Wiggins.
In fairness, Mr. Brooks, you should indicate that the numbers which you mentioned, $17 million, were not improvements on the president's property, but included that entire military office complex out at San Clemente. Now, isn't that a fact?
Would the gentleman
Allow me to respond.
Well, I know the answer. If you'd affirm it, then we can move on to the gentleman's time. That is the correct state of affairs.
I wish you would give him the breakdown on it. It'd be helpful.
Well, you know you're not talking about the president's property. That property is owned by the Coast Guard out there. I'll go back to this gentleman.
Would you?
30 seconds of the gentleman has expired.
May I proceed, Mr.
Gentleman
Chairman?
from Iowa.
Thank you, Mr. Chairman. I think I would set a higher standard even than the gentleman from Ohio, Mr. Seiberling. It seems to me, ladies and gentlemen, that a president has a very high obligation to set a good example to the American.
First, I'd like to say that I do not wish to ascribe any malevolent motives to the majority members of this committee, and the timing of this issue, I think that it's an important issue which should be discussed, and prime time is as good as any other. I'd also like to suggest to Mr. Brooks that it's my hope that this committee will, in its good wisdom, see fit to reject both of the ties that the gentleman has selected.
On next Tuesday.
Yes, the chair so states.
Thank you,
And
Mr. Chairman.
the committee stands adjourned until further call of the chair.
And thus the first step in the impeachment process against President Richard Nixon comes to an end. The committee winding up its formal debate, its formal deliberations today, having approved during 5 days and parts of 6 nights of debate, having approved 3 articles of impeachment that, if ultimately carried through in the impeachment process, would lead to the removal of Mr. Nixon from office. Today, the committee approved a 3rd article for inclusion in its impeachment resolution, but turned down 2 additional articles. This evening, rejecting an article charging the president with willfully trying to evade income tax payments and unlawfully using federal funds for personal purposes. And there you see the final session of the committee members leaving their seats and now beginning to file out. As you just heard Chairman Rodino say a moment ago, the next step is that the committee must file a formal report of its proceedings. He said that would be ready by next. Well, we can talk some more about this in a moment, but Carolyn Lewis is ready outside the Judiciary Committee room.
I've brought out from the committee room Mr. Wiggins and Mr. Waldy. They are a Republican and a Democrat, two gentlemen who have been on opposite sides of the fence in this. First of all, let me ask you, Mr. Wiggins, it's 6 days later, more than 35 hours. What do you think has been achieved here from your point of view?
Well, it's clear what's been achieved. The president's been impeached on several articles. That's been achieved. I don't personally regard that as much of achievement. I personally believe that conclusion was unwarranted. I certainly respect the opinion of my good friend and colleague here, Mr. Waldy, to the contrary, and we will have an opportunity to debate it further, Jerry, on the House floor. That's the purpose of our committee's deliberations, was to make recommendations to the House, and we have now done that.
What about you, Mr. Waldy?
Well, I think there have been a number of things achieved or accomplished, and I think perhaps the most important is the education that the country might have obtained from the 6 days of debate. Obviously, I think the committee has performed in a manner in which I personally would have desired that it do so. We will now carry on this debate in the House of Representatives, and hopefully the level of that debate will remain as high in the House as it has been in the committee. And in that regard, though Mr. Wiggins and I differ, I want to join with many in the country that have commended him on his stalwart defense of the president when he has a very weak case.
Let me ask you both. Now, are you at this moment looking at this really as politicians or as members of the committee? But Mr. Wiggins, how do you think you're going to go down in history after your performance these 6 days?
Very rapidly, I suppose. I don't think I'm going to get up in history, let alone have the opportunity to go down. This is a fleeting moment of history, and it is an important moment, and it's, I suppose, of some significance maybe to me alone to have participated in it. But I don't even for one moment expect that I'll be any more than a footnote in some research tome.
What about you, Mr. Wolf?
Well, in my book, he'll be more than a footnote. But I think all of us hope, if we go down at all in history, if there's any mention of this proceedings, that we'll be mentioned as having attempted to be fair, and having acted out of conscience, and having acted responsibly. Though people might differ with the result, I would really hope that they would conclude that there were men and women of good conscience attempting to come to conclusions upon varying interpretations of facts.
Mr. Wiggins, do you think that these proceedings will have restored the people's faith in our system and maybe raise the position of Congress in the eyes of the public? How do you view it that way?
I think that this is perhaps the first opportunity that the people have had to see the committee process working. The fact is that deliberations such as this go on all the time here in Congress, but we perhaps often do not get the credit for the quality of debate and consideration given to governmental subjects. We are not atypical, I think, of the Congress. There are many good committees of Congress giving consideration to important subjects all of the time.
What about you, Mr. Waldy?
I would agree with Chuck's assessment. I think that the House of Representatives may very well have benefited from the country's view now of Congress as a whole. But I do think we are not atypical, that we are quite typical of many committees in the House of Representatives.
Very briefly, what's the first thing you're going to do now when you get home?
I'm going to go to bed. I may take a shower first, but I'm going to go to bed and start preparing tomorrow for the next phase of these proceedings.
What about you, Mr. Waldy?
I'm going to start preparing tonight.
Really?
If Chuck's going to start preparing tomorrow, I'm going to start tonight.
You have more work to do, Jared.
That's right.
Thank you, gentlemen. Thank you. Back to you, Paul.
Well, I do think in its own way that interview underlines a rather remarkable unity which has existed on this committee. It seemed to me that both of these gentlemen, whereas they were on opposite sides of the fence, nonetheless they did display a goodwill toward one another.